Before I get to their legal arguments for a new trial, as I explained last night, those demanding a pardon seem to be largely ignoring the evidence that led the jury to convict. That Perry ran his car into a group of protesters, that there's no evidence, including testimony from multiple witnesses to the contrary, that the victim, Garrett, ever raised his rifle at Perry after Perry ran into the group. Then there are the Facebook messages posted by Perry before the incident, including things like, "I might have to kill a few people on my way to work, and I might go to Dallas to shoot looters." And the defendant never took the stand during the trial to explain himself, something that is very common in self-defense cases, particularly when I hear people saying he was standing his ground. But Governor Abbott now appears ready to ignore the evidence and just request a pardon. But Perry's legal team is focusing on the evidence, making real legal arguments, which is a very different story. His attorney requested a new trial, saying the judge made mistakes by excluding important evidence. Quote, Sergeant Perry attempted to introduce evidence to show Mr. Foster, the victim's motive, state of mind, and intent on July 25, 2020, by putting forth other incidents in which he was the first aggressor and during which he unlawfully scared other drivers who he believed might interfere with his objective to take the streets. The filing argues that his attorneys also tried to show a photo and video of Foster blocking another man named Joe Sanchez's car with his girlfriend in a wheelchair, as they say happened here. It reads, Mr. Sanchez was prepared to testify that Mr. Foster, the victim, attempted to intimidate him and that he was terrified by Mr. Foster's actions, as well as the actions of Mr. Foster's fellow protesters. Sergeant Perry arguing that he wasn't able to present enough evidence that Foster was the aggressor. The court documents also saying these incidents show that Mr. Foster and his fellow protesters were not the intimidatees when dealing with cars on the public streets, but rather they were the intimidators. Agree or not, these are legitimate legal arguments, void of phony pardon politics. Joining me now is Rick Cofer, who served as a prosecutor in the Travis County District Attorney's Office, which prosecuted the case. Thanks very much for coming on the program. Appreciate it. All right, so let me ask you, just generally, what do you make of this motion being filed by Sergeant Perry's legal team? Do you think they have any winning arguments?
It's good lawyering on the part of his defense team. He has very capable attorneys. I think the media has missed the meat in this motion. It's the last 2 pages. The defense team has secured an affidavit from one of the 12 jurors in this case. And there are some explosive allegations in that affidavit of juror misconduct. The juror, whose name is redacted in the filing, alleges in the affidavit that one of the other jurors actually brought some outside information into the room. The jurors are instructed not to do independent research, and it's alleged that another juror brought in a different definition of self-defense contrary to Texas law. Additionally, an alternate was present for the deliberations. It's accused in the affidavit that while this alternate didn't actually speak, the alternate nonetheless participated in deliberations through nonverbal communication, like gruffing and huffing and gasping and making loud noises expressing displeasure. That could be grounds for a motion for new trial.
These sorts of arguments happen a lot, right? Juror misconduct, but this does seem like, if it's true, meatier than some of the typical arguments about, well, jurors weren't paying attention or jurors did some of their own outside research, et cetera. But it's still very tough, is it not, to get a new trial even when you have issues with the jurors?
Absolutely. And for the fans of Daniel Perry, and I don't have an opinion one way or the other in that regard, they shouldn't get their hopes up too high. It is a high legal standard in the state of Texas to win a motion for new trial. And even as to the issue of juror misconduct, it must be such that it made a material difference with a objective, reasonable juror.
But let me ask you this. Let me ask you, do you think that the pardon issue, though, is going to be resolved before these appellate issues are?
I don't think so. While in a very hyper-technical sense, under the Texas Constitution, sentencing doesn't have to occur before a pardon. There is a process. An application is necessary, a review by the Board of Pardons and Paroles. All of that needs to happen. I would expect that the motion for new trial would be heard and ruled upon by the judge before the parole board and pardon board even is able to meet.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.